system, and perhaps even multi-provincial circuit courts of appeal to break another problem of local interest, and in his most expansive reading, saying China needs to get past the emperor culture, people going to the government to seek as an act of grace, some benefit rather than pushing as a matter of legal right. And these gain uneven traction, but they're part of the discussion in a way that was not true not too long ago. Beyond that, there are demands from and habits of economic winners. People get property, they get wealth, they kind of like to protect it and think the law is one way of protecting that. You're seeing this middle class drive for legal rights in a way that, again, is a phenomenon of this generation. That's a picture of the protest movement, the middle class protest movement that shut down the previously approved but not built chemical plant in Xiamen, which is quite celebrated a couple of years back. And also demands for justice from losers. The people who are responsible for the 100,000 incidents a year are often and increasingly, I would argue, invoking legal norms, even if they're not actually litigating. A couple of other things, just to put this in comparative context as I close. One is, if you look at cross-national comparisons, there was, the East Asian model, as you all know, was the development model prior to the Asian financial crisis, and then it went away, and now it came back again with the Western financial crisis. But there was this idea that you could have an authoritarian model of market-oriented development. Well, nobody ever really worked out quite what role law played in that. And although I don't have time to go into the details, I would suggest that if you look at the way most people have assessed Japan up through World War II, Taiwan, Korea, Singapore, Hong Kong, and China, there are very, very different roles that law plays in those systems. And it may be little, it may be a lot, but it's all quite diverse internally, but it is relatively high compared to the baseline of where the Chinese mainland has been. If you look at the rule of law in Chinese courts, a lot of the criticism focuses on the lack of autonomy of individual judges, and sometimes the lack of autonomy of the courts. And that's a genuine problem. On the other hand, people who are very much pro-legality and pro-legal reform in China will tell you quite sincerely, and I think quite correctly, that there are a lot of lousy judges out there. There are a lot of corrupt judges out there. And to have the adjudication committee, to have a collegial bench, to have various kinds of intervention that, from our perspective, undermine judge autonomy, may actually be a better thing for getting the court's perspective in the long run, and certainly a better thing for getting lawful results in cases. Perhaps not a perfect solution forever, but in a transitional moment, it might be. Beyond that, there's a phenomenon that I haven't worked out yet, and I don't think anybody else in my field has, that we're all sort of grappling with, is this, what I might call gray zones around the law. The evolution of Chinese law over the last 20 or 30 years has had some really interesting phenomena. One is there are practices that are initially unlawful that gradually emerge and then get ratified. The secondary market and land use rights was one example. The so-called small property rights may be an emerging example. Then there are laws on the books that don't really matter, but somehow people wind up invoking them. And sometimes there are laws that aren't even on the books that people invoke. The property rights law is the most famous example here, where people were invoking it to resist land transfers well before the law officially took effect. Let me just now finally close with a quick tour through a few cases that are seen as important moments in the possible emergence of the rule of law in China, or at least recent legal developments. There was the famous Hunan Seeds case, where a judge down in Luoyang had the temerity to strike down a local law because she saw it as inconsistent with a national statute on the topic. This, in a way, is a great breakthrough. It upholds the principle of national legal supremacy. It's kind of a supremacy clause federalism type argument. On the other hand, the local People's Congress Standing Committee intervened to strike down that decision because it was seen as beyond the power of the courts, which indeed it was. Courts do not have that power. So how do you read that case? There's the famous Qiyu case where a woman's identity was stolen by the daughter of a local powerful figure, and she wound up getting into university and going on to a nice career because of that. The victim of the identity theft sued and won on a basis of a court turning to the constitutional right of personality and education. And that was a celebrated case. Some people talked about it as China's Marbury v. Madison. On the other hand, not a whole lot of courts imitated that case, and the Supreme People's Court quietly canceled the interpretation that directed the court in the first place to look to the constitutional provision. If you look at things like the Sun Zhigan case, this is the student who had the misfortune to look like a vagrant, was taken into custody and beaten to death. That led to a very strong movement to repeal the custody and repatriation as sort of informal detention center rules. The hope was that it would generate a constitutional interpretation by the National People's Congress Standing Committee, the closest thing you've got to a constitutional structure in China. And everyone was very excited about this. Ultimately, the regulations were canceled. They were removed. But they were done as an active discretionary choice by the state council. And so this institutionalization of legal input was preempted. Last two cases with some pretty pictures. Legal accountability for state and party officials. You all probably saw the famous nail house case in Chongqing, right? The house that sticks up out of the middle of the construction case, the deLisle, right, the nail house. Well, the two people who lived there became heroes of the property law, right? They said, we are undercompensated for this house, we're not leaving until we get more money. And they eventually got triple the initial offer. A great victory for property rights. The only problem was the law they were invoking didn't take effect until later. So they couldn't actually formally invoke it, but this right was part of the legal discourse and it really mattered. Melanie Milk, the Sanlo Dairy case, those are the unhappy convicts in the Sanlo case. On the one hand, you know, a great victory for the idea of legal regulation as a way of protecting people from serious harm, a condemnation of the officials who failed to prevent this from happening, but and also giving rise to a new food safety law, which may ultimately have some teeth to it. But at the same time, collective action suits were pretty much quashed, and it was a government-brokered settlement and a reliance on the criminal process rather than civil remedies. So you can see these stories coming around again and again, and I'll make one last point and then stop, which is the other interesting over-the-horizon or at-the-horizon phenomenon that I would point to is transnational litigation and its impact in China. We are starting to see in the United States export safety suits targeting Chinese exports. Collective class action suits over drywall and tires and pet food and what have you. And those are an interesting phenomenon. Sometimes you can reach the Chinese defendant, but even where you can't, you reach the American defendant who in turn can't reach the Chinese defendant. And that means the American defendant is very worried about his Chinese sourcing and such, and that is starting to create some interesting pressure backed up by the politics in Washington that may be a new angle, a new avenue into affecting legal behavior. And in this case, we care about results, concrete behavior, not long books, in China. So that's a quick tour of just about everything. With that, I will stop and welcome your questions, criticisms, brickbats, whatever you choose to grab. Thank you.
Thank you, Professor deLisle.